Breaking right now at 5 in a pair of significant decisions. The Florida Supreme Court ruling to uphold a 15-week ban on abortion in the state while also allowing a proposed amendment that would protect abortion rights to appear on the November ballot. Good evening. I'm Tiffany Kenny.
I'm Todd McDermott. Thanks for joining us here at 5 o'clock. Our investigative reporter Terry Parker is here with a closer look at the abortion rights amendment that Florida voters will now decide on this fall. Terry?
Right, Todd. A group of pro-choice affiliates looked at Florida's tightening abortion laws and said, hey, why don't you let the people decide if we want that or not? So they gathered almost 1 million signatures, enough to put the question on the ballot, with the Florida Supreme Court today deciding, yes, it was legally sufficient. But in a separate ruling, the court also upheld Florida's ban on abortion after 15 weeks, which is now slated to change to 6 weeks. That's why pro-choice advocates are trying to put abortion rights in the Florida Constitution.
The people trying to do an end run around their legislators. It has been done in places like Michigan.
Amendment 4 seeks to limit government interference with abortion, saying no law should prohibit, penalize, delay, or restrict abortion in early pregnancy, which is before the fetus can survive outside the womb, or when necessary to protect the patient's health, which would be determined by the patient's doctor. Nova Southeastern University law professor Bob Jarvis says that when the people successfully get enough signatures in favor of an initiative, then it's required to go to the Supreme Court to make sure the language is legal and not confusing to voters.
A voter is not supposed to have to guess as to what it is that he or she is voting on. And while it is true that a voter cannot foresee all consequences of, something that they're voting on, they're supposed to have at least some idea of, if I vote for this, and if this gets added to the Florida Constitution, this is probably the likely outcome.
A group called Floridians Protecting Freedom collected nearly 1 million signatures in favor of the initiative. The state attorney general and anti-abortion groups, however, have argued against it, saying it is misleading. Jarvis agrees there are 3 technical problems with the way the amendment was written.
The first is that it uses the term viability. It says there shall be no restrictions on abortion before viability. Well, what is viability?
Well, Jarvis also says the amendment referred to a woman's health care provider, which he thought was vague, and also there's no reference in the amendment about federal abortion laws and how they could trump state laws. But in this case, the Supreme Court said it's all good. It can go on the ballot.